Listen to me right now because what I'm about to tell you is not rumor, not speculation, and not another political talking point. It is a constitutional explosion that the entire country is about to feel. The Supreme Court didn't just issue a ruling. They detonated an 8-1 decision that has ripped the Second Amendment battle wide open, blindsided the ATF, and sent Washington into full-scale panic mode. This wasn't a quiet opinion. This wasn't a procedural update. This was the judicial equivalent of a missile strike hitting the heart of federal gun regulation. The moment this decision dropped, phones lit up across the DOJ ATF command meetings were called instantly, and state officials began scrambling to figure out whether their firearm laws were about to collapse under the weight of a Supreme Court that just made its position unmistakably clear. What you're about to hear is not just news. It is the beginning of a legal earthquake that will reshape the Second Amendment for an entire generation. The ruling didn't arrive slowly or quietly. It hit Washington like a shock wave. Inside the Supreme Court building, even seasoned reporters admitted they had never seen the atmosphere shift so quickly. The majority opinion revealed a court that is no longer willing to tolerate contradictions, political games, or half-measured interpretations when it comes to the Second Amendment. For years, lawmakers, activists, and federal agencies have danced around the boundaries of what BRE truly meant. They stretched its language, argued its meaning, and hoped the court would eventually clarify its scope without tearing down the regulatory structures they relied on. But the court has now made something undeniably clear. They aren't clarifying Bruin. They're enforcing it. The 8-1 ruling dismantles the argument that modern regulatory concerns can override constitutional text or historical tradition. It slams the door on the idea that government agencies can depend on public safety justifications that did not exist in the founding era. It rejects the notion that rights can be treated as privileges, and it draws a bright, blinding line between lawful regulation and unconstitutional infringement. The ATF, in particular, has been hit the hardest. For years, the agency has expanded, reinterpreted, and aggressively enforced rules that the court now suggests may lack any true constitutional foundation. Overnight, the ATF's most powerful tools have been thrown into legal jeopardy, and their entire strategy for firearm classification is now being questioned through a very different constitutional lens. Inside the ATF headquarters, internal messages began circulating within minutes of the ruling. Agents described the reaction as controlled chaos. Supervisors demanded immediate legal briefings. Attorneys advised caution on pending enforcement actions. Leadership attempted to reassure the agency, but even internally, no one was denying the reality. The Supreme Court has just cut deeper into federal authority than anyone expected. The 8-1 vote wasn't a disagreement among ideological lines. It was a message of overwhelming unity on a case the ATF believed it could defend easily. And now, with that assumption shattered, the AY's ability to enforce a wide range of regulations is suddenly unstable. The single dissenting justice, by the way, did not defend the ATF's position. The dissent was rooted in procedural concerns, not in defending federal authority or claiming the regulations were historically supported. That should terrify Washington. When 8 justices agree that the federal government's position is constitutionally incompatible with the nation's founding principles, the writing on the wall is painfully clear. Federal agencies have pushed too far for too long, and now the judicial branch is pulling them back hard. The core of the decision rests on one principle that echoes through every line of the majority opinion. Rights come first, and regulatory convenience comes last. The court stated repeatedly that the Second Amendment does not hinge on agency interpretations, political arguments, or evolving social standards. It rests entirely on historical tradition, on what the founders understood the right to keep and bear arms to mean. And for the ATF, that is a nightmare because the AY's modern regulatory framework braces, classifications, redefinitions, forms, approvals, restrictions, has almost no historical analog. The majority opinion implicitly calls out the ATF's entire model by pointing out that bureaucratic discretion cannot modify constitutional guarantees. From that moment, legal analysts knew the implications were massive. If a regulation cannot be traced to founding-era practices, it cannot survive. Not might not could be challenged. It cannot. That word cannot is what lit the fuse in Washington, because the ATF's authority over stabilizing braces, certain pistol configurations, import restrictions, accessory classifications, and even portions of the NFA derived from modern interpretations, not historical parallels. And the Supreme Court just said the absence of a historical foundation is fatal. The aftermath has been immediate and chaotic. State attorneys general in gun-restrictive states initiated emergency meetings. They acknowledged that the ruling undermines the legal defenses they have used for decades to uphold strict firearms laws. Their statements revealed panic, thinly veiled, but panic nonetheless. One AG described the ruling as catastrophic for state authority. Another warned that dozens of state-level gun regulations may now be legally indefensible, and they're not wrong. Waiting periods, permit-to-purchase systems, training requirements, transport restrictions, accessory bans, ammunition limits, none of these existed in the founding era and under the court's current logic. Many will be vulnerable in future litigation. Gun-friendly states, however, celebrated instantly. Governors and legislators announced that the ruling justified their previous decisions to eliminate permit requirements and streamline firearm access. Constitutional carry states pointed to the decision as a validation of their approach. Some states even suggested they may reevaluate additional firearm restrictions, knowing the Supreme Court is now firmly entrenched in favor of historical originalist interpretation. You can feel the divide widening in real time. Gun rights groups responded with unprecedented force. Within hours, they filed new lawsuits, challenged existing regulations, and began preparing multi-state strategies aimed at dismantling the ATF's remaining power. Lawyers described the ruling as the biggest Second Amendment opening we've seen in 50 years. Advocacy groups declared the decision proof that the court is finally ready to restore constitutional balance, and individual gun owners flooded social media with reactions ranging from relief to disbelief. On the opposite side, gun control groups reacted with fury. They called the ruling dangerous, reckless, and a threat to national safety. Activists warned that the Supreme Court had abandoned its responsibility to protect American communities. They began pressuring Congress to respond, though legal experts immediately noted that Congress cannot override constitutional interpretation from the Supreme Court. Federal lawmakers can pass new laws, but those laws must still survive the same historical test, and most won't. As emotions escalated across the country, the DOJ found itself in a humiliating position. The department, which had defended many of the regulations now called into question, was forced to reevaluate its strategies. DOJ lawyers reportedly admitted that the ruling will unleash a storm of litigation. They cautioned agencies that enforcement discretion must now be exercised carefully, knowing that aggressive regulation may be struck down as unconstitutional. The DOJ is not prepared for this new judicial landscape, and the tension between federal agencies and the Supreme Court is reaching a breaking point. The ruling's language leaves no wiggle room. It clarifies that constitutional rights cannot depend on bureaucratic permission slips. It reinforces the idea that the Second Amendment is not a second-ass right, and it emphasizes that regulatory burdens, no matter how well-intentioned, cannot cross the line into preemptive restriction. The court openly states that the government cannot pre-screen, pre-approve, or pre-qualify individuals before they exercise fundamental constitutional freedoms. That single statement threatens the entire architecture of modern firearm regulation. As this new legal reality settles, the question becomes, what does this mean for American gun owners right now? The short answer, everything. The ruling opens the door to future challenges on nearly every major firearm regulation that lacks historical precedent. It destabilizes the ATF's authority to create new rules or reinterpret old ones. It invites the courts to re-examine long-standing systems like the National Firearms Act, and it ensures that every future case will be analyzed through the strictest historical standard the court has ever applied. The pressure on the ATF is enormous. Agents on the ground are now questioning how to enforce classifications that may be invalid within months. Supervisors are reviewing guidelines. Attorneys are advising caution on enforcement actions that may trigger lawsuits. The ATF's public credibility has been shaken, and its internal confidence has taken a massive blow. As one insider bluntly reported, the Supreme Court just undercut our entire legal framework. That is not a small admission. That is a crisis. We are watching the beginning of a constitutional confrontation between federal agencies, state governments, advocacy groups, and the Supreme Court. The court has drawn a line. The ATF has crossed that line for years, and now the judicial branch is asserting its authority in the most forceful way it has in decades. This ruling will reshape upcoming elections. It will reshape state policies. It will reshape federal authority. It will reshape American culture. The Second Amendment debate is no longer simmering. It is exploding. The 8-to-1 ruling has made something impossible to deny. The Supreme Court is not retreating. They are not softening. They are not stepping back. They are stepping forward aggressively into the heart of the Second Amendment conflict. They are signaling that they will protect constitutional rights regardless of political backlash or bureaucratic resistance. What comes next will determine the future of American firearm freedom. Will federal agencies comply? Will states adapt or resist? Will Congress attempt to intervene? Will the next wave of challenges go even further? One thing is certain, the ATF is in full damage control. The DOJ is scrambling, and the entire nation is bracing for the next chapter in a constitutional battle that has only just begun.